So the Fifth Circuit is now going to hear and potentially rule on a case that challenges the NFA and the suppressor restrictions, and the challenge is that they actually violate the Second Amendment. And that is set to be heard in December. So let's talk about what is happening in this important case. Now, really quick before we jump into this video, I want to ask you guys that if you're not currently subscribed to the channel, please consider subscribing, then also just double check, because YouTube right now is unsubscribing a lot of people and is just doing some weird things with throttling and shadow banning videos in the lead up to election. Also, I want to thank one of the main supporters of this channel, which is Blackout Coffee. Now, I know every time I bring up Blackout Coffee, people get it confused with a different company called Black Rifle Coffee. Blackout Coffee is a completely different company. It's owned by a friend of mine, Jared from Guns and Gadgets, and they are pro-Second Amendment, they're pro-freedom. They have dedicated roasts for organizations like FBC, GOA, and others. So if you want to get amazing coffee and support the 2A cause, check out Blackout Coffee using the link down below. And also, if you use the code ARMSCHOLAR, you can get 10% off of your order. Now, as I mentioned in the intro, in this video, we're going to be discussing a challenge that is currently in front of the Fifth Circuit Court of Appeals, which deals with the constitutionality of the NFA as it applies to suppressors. The case we're going to be talking about in this video is the United States versus Peterson. This case involves an individual who had a gun store that was raided by the ATF. Now, during this raid, the ATF found a single solvent trap that was not registered or serialized in compliance with the NFA. And because of that one item, Mr. Peterson was charged with violating the NFA and was charged criminally, and currently his case is up for review in the Fifth Circuit. Now, the facts around this case are very interesting, and both the ATF and Mr. Peterson kind of tell a different story based on the briefs. According to Mr. Peterson, on June 29th, 2022, both federal and state law enforcement officers executed search warrants and arrest warrants at his home in Louisiana. The local sheriff executed a search warrant, and the arrest warrant was based on some delinquent, I believe, parish taxes, so some taxes weren't paid, and so they were serving a warrant at his home. Now, attached with that local task force, there was also a federal task force, and the law enforcement included about 50 law enforcement officers from the ATF, the DOJ, and I believe other federal agents as well. Now, when it came to the federal search warrant, because there was also a federal search warrant, that was all based on some of the operations that Mr. Peterson had in a gun store that was operating out of his home. Specifically, the ATF alleged that there were straw purchases going on, that there was some improper record keeping, and that also he failed to file some additional paperwork. And they claimed that some of the products and some of the firearms sold out of Mr. Peterson's home store, that those then showed up at crime scenes, and they claimed that there was a bunch of those that were tracked back to Mr. Peterson. Now, during this raid, the federal agents seized his entire inventory, which totaled about 300 firearms. Those were both personal firearms and then also business firearms that he was selling. They also seized all of his records, and they also confiscated some of the electronics that they found at his home. But here's where the crux of this whole case started. During the search, the ATF found what they determined was an unlicensed suppressor, and that was in his personal safe in his bedroom. So out of this entire incident, it was the possession of that single solvent trap that the ATF found that got him in trouble. Now, back in 2022, he was indicted by a grand jury and charged with violating the NFA because he knowingly received a firearm not registered to him under the NFA. Mr. Peterson and his attorney tried to get the charge thrown out by using a motion to dismiss by arguing that the NFA is actually unconstitutional under the Second Amendment. Now, the district court ultimately denied that motion, finding that silencers are not bearable arms protected by the Second Amendment. That decision by the district court is now set to be heard and argued in front of the Fifth Circuit Court of Appeals during the week of December 2nd. That means now that a pure Second Amendment challenge to the NFA as it applies to suppressors and its restrictions under the NFA will actually be heard by the Fifth Circuit before the end of this year. So this is an important case that we need to talk about. The question the Fifth Circuit is set to decide on is whether the district court erred by finding that the silencers in question are not bearable arms covered by the text of the Second Amendment, and even if so, whether Mr. Peterson's indictment for possessing an unregistered silencer still violated the Second Amendment. Now, I do want to state from the outset, when you look at the arguments presented in the briefs by Mr. Peterson's counsel, there is no mention right now of any of the cases in any of the precedent out of the Supreme Court in regards to New York State Rifle and Pistol Association versus Bruin, the U.S. versus Rahimi case, any of the ATF challenges when it comes to the cargo bump stock decision, any of the Fifth Circuit precedent when it comes to those cases either, like pistol braces, unfinished frames and receivers, FRTs, none of that is referenced in these briefs. Instead, what it appears is that they are still using an old type of analysis, which is tiered-based scrutiny, which was actually expressly rejected by the Supreme Court in Bruin. And instead, the Supreme Court put in place the text, history, and tradition standard, which is very much more favorable when it comes to the 2A type of litigation and is more favorable to us on the 2A side. Interestingly, even the ATF argues in their briefs that this case needs to be analyzed in light of Bruin, and they mention that Mr. Peterson's counsel is not citing correctly to Bruin and the correct type of analysis. Instead, they are using the old tiered-based scrutiny. Now, in the ATF's brief, they first argue that suppressors are not arms protected by the text of the Second Amendment at all. They claim that they are not bearable items and they are not weapons that shoot a projectile. At best, the ATF claims that these items are simply accessories, but as accessories, they are not protected by the Second Amendment. They then argue that even if these suppressors are arms, they are still dangerous and unusual weapons, and because of that, they can be regulated by the ATF. The ATF's last argument is that even if these items are protected by the Second Amendment, the process to register these items is not so burdensome, and this type of process is in line with what they claim is the Bruin analysis, where Bruin had a shall issue scheme. They said that shall issue was okay when it came to CCW permits in a CCW permit process, and they argue that similarly, when it comes to a shall issue NFA suppressor process, that would also be constitutional under Bruin. So they're trying to use Bruin to validate this shall issue, or what they claim is a shall issue, a suppressor scheme where you register these items. So that is the position that the ATF is currently taking in this lawsuit. Now, like I mentioned, in contrast, Mr. Peterson's attorneys argue that the NFA does violate the Second Amendment and that it would not pass means and scrutiny. Again, I want to mention that that is not the correct type of analysis that an attorney should be using when it comes to a 2A case, because Bruin is the correct precedent, Rahimi is the correct precedent. That is the type of analysis that you want to use, text as informed by relevant history and tradition, also because it is way more favorable when it comes to 2A cases. But unfortunately, they're still using the old means and scrutiny test. Now, Mr. Peterson's attorneys argue that the defendant's motion to dismiss must be considered in the context that the indictment charged him with knowingly received and possessed a firearm. Paradoxically, the government now argues that the device for which the defendant received and possessed is not a firearm, to deny the constitutional rights of the defendant as provided by the Second Amendment. Now, this is one of the strongest arguments made in this whole case, because this shows how the ATF is kind of talking out of both sides of their mouth. The ATF is arguing that these are not arms, and as non-arms, they are not protected by the Second Amendment, but at the same time, they have charged him with possessing a firearm in violation of the NFA. So in this very case, the ATF is saying that these are firearms, that he violated the federal law when it comes to these types of firearms, but then also they're saying, well, these aren't firearms, these aren't weapons, and therefore they're not protected by the Second Amendment. So you can't have it both ways, and that's what the attorneys are pointing out here in this section of their briefs. Now, when it comes to this case, all of the briefs have been submitted to the Fifth Circuit, and right now the Fifth Circuit has just issued an order setting tentatively for this case to be argued and heard in front of them during the first week of December. So during the week of December 2nd, the Fifth Circuit is going to hear arguments on the constitutionality of the NFA when it comes to the whole process for suppressors and these types of items, and whether or not this whole NFA process actually violates the Second Amendment, which is a huge issue. So before the end of this year, the Fifth Circuit will hear on arguments about the constitutionality of the NFA as it applies to suppressors. Now, I've also talked to a couple 2A organizations, and I'm trying to persuade some of them to file amicus briefs to the Fifth Circuit, at least outlining how Bruin should control on this issue, how this type of process and the NFA at large would violate the Second Amendment under the Bruin analysis. Right now, we're trying to get that worked up. I'm trying to do everything on my end because we definitely don't want this case ruled on and decided on based on the wrong type of analysis. We want Bruin to be used in this case, and right now it's simply just not being argued. It is being argued, but only by the ATF. We definitely don't want to lose this case on constitutional grounds because a decision upholding the NFA process can have some bad downstream implications, not just for the Fifth Circuit, but other jurisdictions and other circuit courts that would then point to the Fifth Circuit saying, well, the Fifth Circuit found that this NFA process as applied to suppressors is actually constitutional and that suppressor restrictions don't violate the Second Amendment. We definitely don't want something like that, so we want to add as much support to this case as we can. So a very important case that is now going to be heard by the Fifth Circuit before the end of this year, and if anything else changes, I will let you guys know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm. and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.